Good, good morning. This is about community certificate, purchasing property of scheduled caste people, which was given free of cost by the government by a scheme. Very wide area of understanding the law. So probably the leaders of victims community have no sufficient time to concentrate. Therefore, I request the advocates who are concentrating on the right of downtrodden people must go through the judgment and protect the rights of downtrodden people. See AR 2022 SC 322 Bahadur Ram versus Jasaram. Actually, this man claiming that he is a resident of Punjab, but he purchased land in Rajasthan from the land which was allotted to scheduled caste people. That was subsequently set aside by the authorities. It was challenged by one authority, and finally single writ petition filed, then division bench writ petition filed, then went to Supreme Court. Supreme Court has categorically held that by Representation of People Act section 21, who is ordinarily resident. Ordinarily residents means those who resides there. Since the property of his forefathers are there at Rajasthan, he cannot claim that he is resident of Rajasthan also. That was the finding. Therefore, two things they have explained after discussing about the judgment. AAR, this is AAR online 2018 SC, page 1076, Rajanna Kumari versus State of Uttarakhand. Then AAR online 1990 SC 5, Action Committee, that is called Action Committee case. Therein they say merely because in the migrant state the same caste is recognized as a caste, scheduled caste, a migrant cannot be recognized as scheduled caste of migrant state. If you are going some other state and you cannot claim your community rank or facilities or privilege or reservation, even though the community which you belong in your particular state is recognized as a scheduled caste. Very wider judgment. Kindly concentrate on this and do the needful if somebody approaches you. It's all right. Then one of my subscriber wanted to know what is the motor accident claims tribunal cases procedures. See, Motor Vehicle Accident Claims Act clearly says that as soon as the FIR is registered, the copy should be forwarded to tribunal, and the tribunal so moto take that report for granting claim. Number one, that is being ignored. Thereafter, the copy is also be forwarded to legal authority, and the legal authority can also give legal aid. Even the hospitals where these victims were admitted, legal authority act posters were affixed earlier, but I do not know whether it was fixed now or not. But actually, this is this motor accident claim cases are being conducted by fomenting litigation, which is professional unethic. But however, see, the litigants also not good. they always want to follow uh, the illegal means, illegal ways, because therefore they accept the advocate recommended by the traffic investigation police officials who sells the brief for 10,000, 20,000 to the advocates who approaches them. This is business going on. We cannot stop it. But the litigant, being informed by the very same constable that the advocate will finance you also. So the advocate who appears, not all advocates, some advocates appears in MACTOP cases, invest the money, lend loan or other need of the litigant, and the litigant is also addicted to that. Therefore, how could we blame the advocates alone? But it is the duty of the uh, uh, ethical maintaining, moral regulating authorities, including High Court and other head of the judiciary, to have some check. It's all right, I can say. Therefore, but what I mean to say, the litigant can very well send a letter to Chief Justice if you want emergent disposal of your case, to refer your case by mentioning the case number to the Chief Justice, and that will be forwarded to Permanent Lok Adalat, Maha Lok Adalat. You will be awarded, there will not be any bargaining to minimize your claim. The Lok Adalat presiding officers helps you to get proper and accurately calculated compensation, not more than that. So that's all up to you to decide. Justice.